All right, everyone. As you already heard, my name is Elan. My firm is EJD Law Group. I am an attorney specializing in several different areas of the law. The very first one, by far the biggest one in my practice, is construction law. That is the reason I joined this group several years ago. I think I've told you before that contacted Paul, told him kind of what I do, thinking that this may be a good fit. One of the best decisions I've ever made was to join this group. So I'm very thankful to Paul and all of you for welcoming me. So some of the things that I do specialize in with respect to construction are contracts, disputes on jobs, kind of like what I talked about today, payment disputes. You have that difficult client that doesn't, want to pay. Mechanics, lien, stop notices, that goes hand in hand with that. If there are ever claims against my client's bonds, I represent them in that. Supplier claims. Now, I know that none of you have ever dealt with any of these things, but if there are ever defective construction claims, I also represent my clients in that. So I kind of, with respect to my construction practice at least, tell my clients, for 95% of my contractor clients, I would say that I act as outside general counsel, where I'm kind of the one-stop shop of, whether it's a big job or whether it's something that pops up on a specific project where it needs to be a 2-minute phone call of, hey, Elan, I had this one thing come up. What do you think? That's kind of the way I like to work with my clients. Some of my clients, it's just specific scopes, but most of my contractor clients, it's just kind of like general counsel. I'm able to handle almost anything when it comes to construction law side of things. Of course, there are specific things that come up every once in a while that, I'll say, hey, I don't handle that, but more often than not, I have somebody who can handle that if it's not me. So that's kind of my construction practice in a nutshell. Next biggest one is general business law. I know I've talked about it before, business formation. And then after you form the business, there's a lot of people out there, a lot of business owners that think, okay, I formed the business, that's it, I'm done. No, there's actually a lot of things that should be done. You got to maintain your corporate formalities. And a lot of people don't think it's a big deal. And it's not a big deal unless something happens. And that's kind of how it always is. And the whole point of maintaining corporate formalities, and that's things like having shareholders meetings, having minutes of those meetings. These are all legal requirements, because if something is to ever happen down the line where your company gets a judgment against it for whatever reason, if you don't maintain your corporate formalities, there is an actual legal process. I'm sure many of you probably heard of it, but you can pierce the corporate veil, which again, everybody forms a business entity for the purpose of liability protection, to not being able to go after the owners of the company, the personal assets. Well, if you don't maintain your corporate formalities, there is a way that actually they can go after you personally. It's difficult, but there is a way. So, I always advise my clients to make sure you're doing those types of things. It's not difficult, but it's important. Also help with kind of same thing, contracts, disputes, partnerships, disputes, drafted buy-sell agreements, stuff with payment. And again, I do both transactional and litigation. I do a lot of real estate work, development. Lately, there's been a lot of lease issues, landlord-tenant disputes. I've had a lot of those lately. Mostly, I represent landlords by far. I have helped some tenants out, but it's mostly on the landlord side. Some quiet title actions. I got a couple of those right now where people are trying to steal title to property. Foreclosure, land use, easements, and again, transactional and litigation on that. Then insurance coverage. Now I know it's a super broad term, but when I say I do insurance coverage work, that's helping either business owners, most of the time it's homeowners, with insurance claims that have been wrongfully denied or grossly underpaid. I know you've all heard Amjad come in and speak that they specialize in mold and water damage restoration, remediation, and that's usually after insurance claim. So if there's ever, they make a claim, you have a leak, you may claim your insurance company, you think they're going to come in and pay. Oftentimes they don't, they find some way to deny the claim. That's where I come in and help them. Or again, they only want to pay for a small portion, also help them with that. And pretty much any kind of insurance claim, I can handle any of those. Now, this is a part of my firm. I don't advertise very much. I don't talk about it too much. But it is something that I certainly have the ability to do. I have a lot of experience in it, and that's personal injury. It's not my favorite area of the law. It's not the most exciting, in my opinion. There's a lot of people that love it, but I definitely have a lot of experience in it. I do handle it. So if, again, you guys do know someone that's ever been involved in any kind of accidents, I can definitely help them with that as well. And, again, pretty much any kind of accidents I can take care of. Now, a topic I wanted to talk about, minus the just what about my firm and what we do, is something that I think could be beneficial for most of you. I know not all of you are contractors, including myself, so this probably doesn't apply to you, but it does help all the contractors in this group. And I've talked about it, I think, once before, but it was when we were still on COVID times on Zoom, and we were split into two groups, and the group was much smaller. So I wanted to talk about it again, and I've added some stuff to it because I think it'd be super beneficial for all the contractors in this group, because I'm sure you guys are knowledgeable as to mechanics, liens, and stop notices as contractors, as being in the business for a long time, but maybe I can just refresh a couple points, and if I can do that, I think I've done my job, because it's very, very important for any contractor to know the lien process, because hopefully no one ever has to use it. But again, if there's that client that doesn't want to pay, that wants to stiff you, this is a very, very effective way, in my experience, of getting them to pay, because it gets a lien on their property. I'll talk about a little bit of the differences at first of what a mechanics lien and stop notice is. They're both ways or procedures for a contractor to be able to get paid on a job. Mechanics liens, they actually attach to the property, so the project, whatever that is, you can attach a lien to it, while a stop notice, that just attaches to funds that are being held by, most of the time, the owner of the property, or if it's a bigger project, maybe there's a lender on the property. So that attaches to the funds and just creates a freeze on the funds. So if there's a stop notice, whoever it is that's holding the funds, really can't release them until everything gets figured out, until everyone gets paid. So that's the main difference of the two. Most of the times you're dealing with mechanics liens, but sometimes there are stop notices. Who can record either a mechanics lien or stop notice? Pretty much anybody who's working on the job. So direct contractors, another term for general contractors, subcontractors, suppliers, design professionals, so architects, engineers, again, pretty much anyone working on a job, as long as you're licensed, can record mechanics lien or have a stop notice. Now, public versus private projects makes a difference, because stop notices are available on both, while mechanics lien are only available on private projects. So if you're doing public work for city, county, whoever it may be, mechanics liens are not available under those projects.
Is it true that if you work directly for an owner, you don't need to file?
So what you don't need is, and that's on this slide, is you don't need to do a preliminary notice, but you still have to record a mechanics lien if you want to foreclose on it. So that is the difference, though, for the preliminary notice. So one of the first requirement to be able to record a lien and then later foreclose on it and enforce it is you have to serve what's called a preliminary notice. Has to be within 20 days of starting work. And the whole point of this preliminary notice is just to give the owner of the property, of the project, notice of who is actually working on the project, so they know. So on to Pierre's point, a general contractor or direct contractor doesn't have to serve preliminary notice, because it's kind of counterintuitive. The owner of the project, or whoever's hiring the general contractor, obviously knows that person is working on the project. So you don't have to go give them a preliminary notice, because they already know. But again, if there's a bunch of subcontractors underneath that owner doesn't know is even really working on their project, that's why they, suppliers, any of those types of people have to serve the preliminary notice in order to even preserve their right to record a mechanics lien, because the requirements are really strict. I've seen a lot of times where this process isn't followed, and then they go file a lawsuit to try to foreclose on a mechanics lien, and they're able to get out of it really quickly because they didn't follow the proper procedures, and they're super strict. So that's why I always tell my clients it's important that you do this correctly, or else you're kind of out of luck. Now, who must be served with a preliminary notice? The owner. If it's a subcontractor, you have to serve the general contractor, so the general contractor has it too. And again, if it's a bigger project, there's a lender also have to serve the lender. So that all depends. And then you have to do service a specific way, either personal delivery, so actually handing it to them, or by mail. But again, if it's by mail, it's got to be registered, certified, express, or overnight. So it can't just be snail mail. That's not good enough. So again, got to make sure that you comply with these requirements. Now, there's also specific time limits that you have to record a mechanic's lien. So you got to know these and make sure you're doing it within these time limits, or again, you're out of luck. Most projects, at least I've seen, they don't, get notices of completion that are actually filed or recorded. So this is going to be generally the timetable that applies for most projects. So if there is no notice of completion that's actually filed or recorded, then generally it's 90 days for the most time. It's 90 days from actual completion of the whole project. Or if, let's say, your specific work was done way before than the whole project was done, it's 90 days after or within you finish your work on the project. So it's not just, if you stop work towards the beginning of the project, but the project still has another year to go, you can't just sit there for a year and say, I'll record later. It's got to be 90 days within your specific scope that stopped working on the project. So it's not, 90 days, so you got 3 months, but again, just know that 90 days is in there so you don't sit on it for too long, because then, again, out of luck. There are a couple other ways where it says here cessation of labor, just fancy term for stopping work. So it's generally, again, that 90-day period. If there is a notice of completion, then you either have to record within 60-day notice of the completion recording date for general contractors and 30 days for subcontractors and suppliers. So it's a shorter period. That's why you kind of got to know, is there a notice of completion that's being filed? Just kind of keep your eye out for those things. So that's just the recording of the mechanic's lien. The next step is to actually foreclose and enforce the mechanic's lien. And all that means is you have to actually file suit in the Superior Court to enforce that, and that must be done within 90 days after recording your lien. So you have the preliminary notice, then you record your mechanic's lien. Again, if you get paid, obviously no need to do it, but if you're not getting paid, you record the mechanic's lien, and then you must file this lawsuit within 90 days, or again, you'll lose your right to do that. So that is a very important deadline, because the statute of limitations will expire, and out of luck. Stop notice, a little bit different on the timetables, but the process itself is pretty much the same. And again, it does make a difference whether it's a private project or doing public work. For private work, if it's a general contractor or prime contractor, no later than 60 days after a notice of completion or notice of cessation was recorded. Or, like I said, if none of those are recorded or filed, 90 days after completion of the work. If you're a subcontractor or supplier, not later than 30 days after notice of completion or cessation, or 90 days, again, same thing, if none of those are recorded. On a public work, actually a general contractor has no rights to give a stop payment notice on a public work, but subcontractors and suppliers still do, not later than 30 days after notice of completion or cessation, or 90 days after the public entity actually accepted the work, or when no work has been done for 60 consecutive days. And then same thing, lawsuit must be filed within 90 days after delivering the stop notice. So I'm sure you see the pattern is the 90-day mark. There's a lot of those 90-day marks, and that's kind of the rule of thumb. But again, make sure that you or whoever it is that's handling for you guys are aware of these deadlines, because they come up on you, and you have to make sure you're complying with them. Now, last but not least, who can enforce mechanics liens? And I touched on this earlier. Only licensed contractors have lien rights. So, no contractor out there who doesn't have any license, or who doesn't have a license for the specific work that they're performing, they cannot go and record mechanics lien. I mean, well, I guess they can, because you can record anything, but they're not going to be successful on foreclosing or enforcing it, because again, they're not licensed. They do not have any lien rights whatsoever. So again, California is really big on only licensed work being done. This is one of the things they do to persuade everyone from getting the proper licenses, or dissuade individuals from working without a license, because they have no lien rights. So They can't do any of these things that we just talked about. Now, to go a little bit further on the whole license issue, Business and Professions Code 7031, that's the specific statutory code that talks about licensure in California. And again, because California tries to do everything in their power to persuade everyone from having a license, they have some of the strictest laws in the entire nation, in the sense of a licensed contract, or excuse me, an unlicensed contractor, and I guess then they wouldn't really be a contractor if they're unlicensed, but an individual doing unlicensed work have absolutely no rights, not only to foreclose on any liens, but they have no rights to even file suit for non-payment. If you read 7031 subsection A, it says no person engaged in the business or acting in the capacity of a contractor may bring or maintain any action or recover in law or equity in any action in any court of this state for the collection of compensation for the performance of any act or contract where a license is required by this chapter. So again, in other words, if it's an unlicensed contractor or person doing work that they're not licensed for, and that client says, I'm not paying you, they cannot go and sue them and go ask a court to give them a judgment of, hey, I did this work for this person, they need to pay me. And the judge or the jury, whoever it might be, could say, well, are you licensed for that work? No? Well, too bad. Sorry. I mean, you should have gone and gotten a license because of 7031A. So, people doing work without licenses can get really, really, screwed in these situations. So that's why, again, I only deal with licensed contractors, but if I ever get someone that comes across that isn't licensed, like, go get your license, because it could cause a lot of problems. Now,
well, I have a question. I deal with this all the time.
Yeah.
Can you also talk about what a legal 1099 is? Because a lot of contractors don't know, and I have to educate them. And they say, oh, I 1099 that guy. I'm like, that's a crime.
Right, exactly. That's a different issue, but yes, that happens all the time. And then 7031B, it's kind of that exact thing, but inverted, in that if somebody hires someone to do work on their home, it could be a commercial property, whatever it might be, and that person is unlicensed, or again, unlicensed also means, let's say you hire somebody to act as a general contractor, but they don't have a Class B license. That's also an unlicensed individual. They can't be a swimming pool contractor, acting as a general contractor. That's also considered unlicensed work. So if someone hires an unlicensed contractor to do work, they can sue them and recover every penny that they paid to that individual. It doesn't even matter if the work was pristine and perfect. They could go and get every, penny back. I've seen it happen. Again, I think it's tough, especially when the work is good. But for example, you hire someone to do a remodel on your home and you pay them $200,000, and at the end of it, you're still very happy with the work. The work is good. If you wanted to be extremely, tough, and you found out that persons were unlicensed, or even if you knew the person was unlicensed the whole time, you could still sue them and say, I want every penny of my $200,000 back because they were unlicensed. So again, it's super, super harsh, but California put these things into place to persuade everyone for getting the proper licenses, having the proper insurance, and do everything under the license statutes. So that is it in a nutshell. I wanted to end with that. And again, obviously everyone here, of course, I know is licensed, but if you guys have any colleagues that are doing any type of stuff, talk to them about this, because it could cause a lot of problems.
Thank you.
You're welcome.